morning, and thank you all. And in particular, thank you for your obviously very thoughtful comments this morning. This is an issue that we all agree is one that is profound in terms of how it has impacted our constituents and our state, our families, our neighbors. And we have, as usual, as leaders in California, an opportunity to take a real role of implementing change and solutions in a way that are reasonable and practical and will have impact. And so I appreciate the comments that each of you has made, and I think we all are approaching this with the same spirit of being relevant and making sure that we do the right thing. I believe that the presenters this morning and afternoon will direct their comments to a lot of the points that have been raised that include the economic impact to California and discuss also what was just the issue and the experience that homeowners have had. So I'm going to start with a few comments, and then to my right and left are two of the senior Deputy Attorneys General in the great Office of the Attorney General of California, who are going to also talk specifically about their work in this regard. So thank you, co-chairs Eng and Evans, for your leadership and for all that you have done and will do. We are discussing specifically two bills. The first is the Foreclosure Reduction Act, SB 900. The second is the Homeowners Due Process Rights Act, AB 278. I want to also recognize, before I go on, the leadership and the role of leadership that Speaker Perez and Senate Pro Tem Steinberg have played in this effort. So you've heard the statistics. The United States foreclosure crisis is in its 5th year. And to date, approximately 2.9 million Americans have lost their homes to foreclosure. And we're probably only halfway through this point of crisis. California, as has been mentioned, is at the epicenter. We have, and had last year, frequently 7 of the top 10 cities hardest hit in the country in terms of the numbers of foreclosures we have experienced per capita. It's important to note that in 1933, which was the height of the Great Depression, the foreclosure rate was less than 1.4%. In the 4th quarter of 2010, it was 4.63%. And in February of 2012, although reduced to 2.4, this year we are experiencing foreclosure in California that is twice as great as we experienced during the Great Depression. And roughly 500,000 of those in California were at least 60 days delinquent in terms of their stage of their foreclosure. In the last quarter that has been reported, 12 of the top 20 hardest hit cities in the country are here in California. Although the state's foreclosure rate has slowed somewhat, Stockton and Modesto were the 2 hardest hit cities in America that quarter, with foreclosure rates of about 1 in 60 homes. In 2011, my office alone received more than 300,000 consumer complaints, and nearly 7,000 of them, or about a quarter, were related to the mortgage issue, including complaints about foreclosure consultants and mortgage servicers. This represents the largest portion of our consumer complaints that, as you know, range from online privacy to identity theft to consumer debt collection and consumer scams of every other conceivable form. The Homeowner Bill of Rights is a legislative action, and leadership is needed to preserve homeownership for responsible homeowners, reduce blight in communities, and restore the housing market in California. The California Homeowner Bill of Rights is a package of bills that will address specific aspects of the foreclosure crisis. It will help homeowners stay in their home, responsible homeowners stay in their homes, and assist the California Department of Justice in its ongoing investigation and prosecution of mortgage-related crimes. The 2 bills that are before this committee represent careful work of senior Deputy Attorneys General in my office who have been investigating these cases for years. These bills are common sense reforms to the mortgage servicing and foreclosure processes and will prevent many of the abuses my office has investigated as part of the National Mortgage Settlement. We hear and have heard from homeowners and see in our independent and criminal and civil investigations a lot of what we seek to address with these reforms. As has been mentioned, we were part of a national mortgage settlement. Many of the reforms in the Foreclosure Reduction Act and the Homeowner Due Process Rights Act flow from that national mortgage settlement. And I will provide a little background on that, but as has been noted, 48 other states participated in that process, as did the United States Department of Justice, as did the United States Department of Housing and Urban Development, and as did the banks, and in particular the 5 largest banks of our country, their CEOs and their general counsels. And this process lasted for well over a year, and you can best believe, because obviously the stakes were high, that a lot of time and attention went into this process. And to be sure, there was a lot that was discussed that involved detail, often what might be considered mundane detail. Those issues were also debated, and ultimately there was a determination that the reforms that were put in place as a part of the national settlement were the right thing to do after a careful review over a very long period of time of the specifics and the impact that these reforms would have on all parties involved. One of the investigations, and in fact the first investigation that resulted in the national mortgage settlement, was focused on the issue of robo-signing. It's a term of art, and it basically involved bank employees who were signing foreclosure affidavits without reviewing the accuracy of the sworn statements. And also we identified significant mortgage servicing misconduct, particularly deceptive practices, often in the offering of loans and loan modifications. On a national level, we began to discuss sanctions with these banks and immediately started working on these common sense reforms. We also, as has been noted, reached a settlement that is estimated to bring California alone $18 billion. The settlement involved not only what needed to happen around principal reduction, it involved what needed to happen around refinancing of loans, it involved what needed to happen around short sales, and most specifically, as is before this body, it involved necessary reforms to a system that all agreed needed fixing. And I would suggest that as we go forward and think of these reforms, let's not allow anyone to suggest basically what I believe is a false choice, that when we approach these reforms, it is somehow about regulation of an industry. That is not what this is about. It's about fixing some aspects of this process that so many Californians, responsible Californians, are a part of, in a way that there is transparency and fairness for folks who otherwise want to and do play by the rules and want to do the right thing. Specifically, the National Mortgage Settlement implements the following reforms. It requires that the banks document the right to foreclosure, that they restrict the so-called dual track process by prohibiting the recording of a notice of default when a timely filed application for a loan modification or other loss modification measure is pending. Thank you. It is about requiring that we provide for homeowners going through foreclosure process a specific person to talk to at their lending institution, and it required, the national settlement, that the banks inform borrowers of the reasons for a denial of a loan modification application. All common sense. Again, though these rules are temporary, what is not known, and it has been mentioned, is the settlement has a shelf life of reforms for 3 years. What we want to do in California is make them permanent for all the reasons that have been mentioned. I know there has been some discussion, for example, of the idea of let's put a sunset on this. Well, I'd suggest to you there's no such thing as putting a sunset on due process. When we look forward, we need to have systems in place that can allow the foreclosure process to occur, but in a way that meets all principles of fairness and due process. So one point to mention, in connection not only with the national foreclosure and the national settlement, is there was a key player in that who is the United States Secretary of the Department of Housing and Urban Development, Sean Donovan. He was recently in Los Angeles, and when asked about the California Homeowner Bill of Rights, he too articulated the need for support of such a measure, understanding that the national settlement obviously was the result of, as we have discussed, 50 attorneys general and many other concerned parties' involvement. It was in that way applicable to the entire country and all of its states. But what we know is that the states are diverse. And to the extent that there is diversity among the states, he recognized and supports the idea that each state should put in place rules that are suited to that state. And I'll give you an example of one of the issues that creates diversity within our country on this issue, which is the issue of those states which are judicial versus non-judicial foreclosure states. We happen to be a non-judicial foreclosure state. In judicial foreclosure states, as the definition, as the word would describe, the foreclosure goes through a process where there is an uninvolved third-party review, the court, the judicial process. We don't have that in California. So when we have proposed the Homeowner Bill of Rights, it takes that into account in terms of, as has been mentioned, talking about the need for third-party review and enforceability and accountability of the terms. Specifically, the two bills I'll discuss now. The first is the Foreclosure Reduction Act. One of the issues it addresses there is this issue of dual track. We have held town halls up and down this state, and I'm sure all of you as leaders have met your constituents. They've probably visited your district offices and talked about this issue of dual track, where the homeowner is in the process of foreclosure. They are also in the process of attempting to modify their loan payments, and without notice and without warning, they are foreclosed upon. It is simply an unfair system, not to mention confusing, and in that way, arbitrary, and in that way not helpful to the homeowner or the bank. So what this bill will do is address the dual track problem by prohibiting the foreclosure process from going forward while a modification application is pending. The bill is intended to make the foreclosure process more fair. It is not intended to end foreclosures where there is the right and the need for foreclosure. What it simply requires is due process as a part of the foreclosure process. Indeed, the nation's next largest lenders agreed to this as part of the reason and part of what we need to do to fix the system in the country. And what you should also know, as has been mentioned, the national settlement applies to the 5 banks, the 5 top banks that have been mentioned by Senator Evans. The next 9 largest lenders are not covered by this. And they include lenders like OneWest, U.S. Bank, who both have large portfolios in California. They are not signatories to this mortgage settlement, and it is not clear that an agreement will be reached with many of these large lenders over the foreseeable future. We can also address at some point, and I'm happy to take any questions, the concern that we have about any suggestion that there will be resolution on a national level through the Consumer Protection Financial Bureau. The reality of that, and this is where we get into the real detail, is that that was a recess appointment, and the person who is in that position is probably not going to be able to push through what we'd like to see before we can get it done in California. And I would suggest to you that each day is not equal on this issue. And the sooner we in California are able to act, the sooner we will bring relief and justice to our neighbors and our friends and our constituents. So as we know, preventing dual-track foreclosures will help communities just as much as families. An estimated 32% of homeowners are foreclosed upon in California while seeking a modification that would allow them to pay to stay in their homes. In California, the estimated cost to taxpayers per unnecessary dual-track foreclosure is $19,229. And that includes increased cost of safety inspections, police and fire calls, and trash removal and maintenance, the issue that was mentioned in terms of blight. Without this legislation, based on the more than 500,000 mortgages currently in the foreclosure pipeline in California, we expect that California taxpayers stand to lose approximately $3 billion on the 32% of future dual-track foreclosures that can occur under current law. Preventing unnecessary dual-track foreclosures has also been estimated to save $2.2 billion in lost property value on nearby properties as a result of blight and other spillover effects of foreclosures. And the stories of homeowners being foreclosed upon you will hear, but in my meetings up and down the state, I will tell you the case that you will hear of, for example, a young man by the name of Daryl Davis, who lost his wife a couple of years ago, lost his job, raising his 2 children by himself, and was in the process of going through a foreclosure, wanted to keep his home, wanted to pay to keep his home. So he was going through the modification process. One day someone knocks on his door and tells him, "Your house is about to be sold on the front steps of the courthouse." This is a true story. He didn't know it. And I've heard this story in one version or another up and down our state. And he had to go then to the front steps of the courthouse and urge and beg and plead that they would not sell his home because he was playing by the rules and doing and going through the modification process. This is simply unfair. And it is not about precluding the bank and the servicing institution from foreclosing upon the home and the homeowner that rightly should be foreclosed upon. But Daryl Davis was not that person. And there are many Daryl Davises up and down this state. The bottom line here, as it relates to this bill, is that the foreclosure process should not and must not proceed when modification discussions are ongoing and when modified payments are being made. Homeowners must be told why they do not qualify for a modification. Banks must prove that they have the right to foreclose before recording a notice of default, which is the legal action that begins the foreclosure process. Next, we have, and we'll be discussing the bill that relates to what we're doing in terms of the Homeowner Due Process Rights Act. And essentially what that does is it creates a single point of contact. Homeowners in distress need effective communication with their banks. This bill would require a single point of contact who would be responsible for providing accurate account and other information related to the foreclosure process and loss mitigation efforts. Because obviously the homeowners have a right to and reasonably would want to know who is foreclosing upon them, and they would have a right and logically would want to know why the foreclosure is taking place. What is the basis? Robo-signing cannot be tolerated. Robo-signing essentially was the process by which foreclosures in this country occurred on a mass level, probably in the spirit of expediting the process, but at the expense of due diligence and therefore fairness, at the expense of going through the detail to determine when you stamped that document and declared foreclosure, did that homeowner actually do what they were supposed to do? At the expense of requiring that before you take someone's home, you make sure you have a right to. It's a simple rule of fairness. This rule and this issue would be addressed by this bill. As I've mentioned, California is a non-judicial foreclosure state. We need to have those safeguards in place. The national settlement recognized it, so should California. The bottom line here is that due process changes are essential to making permanent these reforms that will expire in 3 years without our action. We need to extend the thoughtful reforms. They have been included in the national settlement, and we should do this in California. And I would suggest also that as we go through this process, I want to emphasize a point that Mike Feuer made. When material violations of these rules occur, if we are going to truly have relevance and not make this attempt some grand gesture. We have to ensure that we build in accountability through adequate enforcement. Otherwise, these rules don't have meaning. We require it in any other situation, that we will put in place a rule, and if you break it, we have the ability to enforce it. This issue demands that kind of approach, because what is at risk is what we have seen, which is responsible families have gone through a process of losing their piece of the American dream when they should not have had to be in that situation. And we should not let that happen again in our state. So I'll close with those comments.